Okay, we're getting the Voting Rights Act case.
Oh, wow.
All right.
That's a big one. This guy's going to teach me. What is it? It's like,
Okay, Bob. They've struck down the key part of the Voting Rights Act. Just Section 4, right? Okay. Ready on when you are, Bob.
All right. Where is it? This is. All right.
Does not what? So just Section 4, right?
Slow him down. Slow him down.
Yeah.
Yep. Slow him.
No.
Sorry.
Don't slow him down.
Oh,
yeah, I got you.
Shall we?
Section 5 was the question. The question apparently that was the big.
Well, this decision strikes down a key part of the Voting Rights Act and leaves it up to Congress to try to fix it. Now, there were two parts of the law that were in question here. This is the civil rights law signed by President Johnson in 1996, or rather 1965, renewed 4 times, most recently in 2006. It says that states or counties or towns with a history of discrimination must get permission from the federal government in advance before they can make any changes at all in their election procedures. This is the so-called pre-clearance requirement. Well, the court upheld that today, but the court struck down the map, the formula that Congress has repeatedly used over the years to decide who's covered by the Voting Rights Act. Now, this leaves it up to Congress, but the question is, how likely do you think Congress is to do something major like this, to take another look at where discrimination at the polls is a problem, decide who's okay now, who isn't? The Supreme Court signaled 3 years ago that it thought that the Voting Rights Act was out of step with the times. Things have changed in the South, the Supreme Court said then, in an opinion written by Chief Justice John Roberts. And he writes the court's opinion again today. And so the court is clearly leaving it up to Congress. But the question is, can Congress muster the ability to do what was done? Yeah. Well, we'll have to wait and see what the details are here, but there are several requests for pre-clearance still pending with the Justice Department right now that the Justice Department hasn't acted on. We'll probably know here in just a little bit what the details are about what happens now with those pending requests. Some states, for example, New Hampshire, asked to be released from the Voting Rights Act and was, but you know, you have to think about this. The Voting Rights Act passed in 1965 at the height of civil rights unrest in this country. It was a different climate then that led Congress to decide where the problem existed and where it was no longer a problem. It's going to take a long time for Congress to just do the homework, much less to muster the political ability to get this done.
George, as you know, it's impossible to overstate the importance of the Voting Rights Act. It's one of the most important laws ever passed by Congress. Even the conservatives on this court acknowledge its success in transforming the democracy of this country. What the court did today is say it's outdated.
That's right, and the court really did send a very strong message to the Congress back then in another case from Texas, a warning to Congress. So in essence, this is a follow-up on the court's original homework assignment to Congress, only this time it's not just a suggestion, it's a ruling striking down the effective part of the Voting Rights Act.